remanding him into the record. The appellate term on my first appeal said that Peter Lane did have jurisdiction over Charles Dolan, and Charles Dolan, that's forever. Forever in Westchester County, it is adjudicated that Glendora has jurisdiction over you and can give that jurisdiction to any Westchester court. So Peter Lane would not let Glendora read this into the record. She wanted it in her opening statement. She wanted it in her closing statement. Also, Peter Lane was wrong about motion practice. Small claims is not about motion practice. Small claims is you go in for the first appearance in answer to the summons. That's your first appearance. And the second appearance is you go to trial. That's it. There's no motion practice for 2 years in between. You have a right to presume that a judge knows the law and knows how to conduct a trial. Peter Lane does not. So they said that I applied informal pauperis and the production of a trial transcript pursuant to Civil Practice Laws and Rules 1101E. In this small claims action, seeking damages for alleged conversion of certain videotapes, the case started with my suing Charles Dolan and Cablevision Systems Corporation for not returning my videotapes that was sent to be cablecast or public access. Submitted to defendant Cablevision in connection with plaintiff's public access cable program, plaintiff seeking to appeal from a judgment in favor of the defendants. Well, that's very bad English construction. Let me translate it for you and tell you the way it should be. 1. Cablevision wouldn't return my tapes. 2. I sued its chairman, Charles Dolan, and Cablevision Systems Corporation because they did not return my tapes, and I sued for $3,000 damages in the Rye City Court, Peter Lane. Peter Lane ruled that Cablevision return Glendora's videotapes, bring them to the court, that Glendora picked them up, and that when this was done, the case was over and dismissed. Well, that happened. I did pick up the tapes, or my friend's messenger picked up the tapes, and then my friend brought them up to us. But I didn't get the damages that I sued for. So I appealed, and the appellate term, Rudolph, Skelos, and Doyle, ruled that Peter Lane, number one, had jurisdiction over Charles Dolan. Obviously, Charles Dolan's name is all through the county clerk's office as being the CEO of Cablevision. All of these systems that he has in Westchester. So that was stupid. That Lane said he didn't have jurisdiction. It was nothing but unadulterated collusion with Robert Callaghy, who lived in Rye also, and whose paths crossed in many places. Callaghy is now dead. And then the appellate term, Rudolph, Skelos, and Doyle, said that Lane ordered the tapes to be brought into the court and given to Glendora, but the appellate term says Glendora didn't ask for that. So the appellate term reversed Lane and remanded. Now the reverse of deny $3,000 is to grant $3,000. We go back to Peter Lane. He doesn't do a thing that the court tells him to do, that the higher court told him to do. He didn't do a thing. And he wouldn't let me read their order into the record. He let the trial go and let Callaghan drone on for hours about jurisdiction when it was a dead issue. The appellate term have already ruled that the Rye Court did have jurisdiction over it. And when McQuaid came to court for a conference to set a trial date, McQuaid brought up jurisdiction again, and Lane says, I view that as an argument, as a re-argument, and I deny it. So it was dead twice. Then Callaghan ended up being dead. So they let the trial go 6 hours, and that made the minutes about $1,300. As I say, this is all against public policy because you have a presumption that a judge knows how to conduct a trial and that a judge knows the law. As I told you before, the trial could have been over in a half an hour and the minutes would have been something like $100, and that would have been affordable. So I asked Peter Lane, Rich Rye, where his shack goes for something like $600,000, to pay for the minutes, $1,300. And he dodged it once with a stupid objection, which I overcame. Then I asked again, and he dodged it twice with another stupid objection, which I overcame. And then he dodged it a third time, and I'd had it, I appealed. And then I asked the appellate term to pay for the minutes, and they wouldn't. They expected this 78-year-old widow to pay for these minutes for $1,300. Folks, is that right? Now, what do you think of that? Is that a state? Or rather, is that a situation where state judges should get a raise for doing that kind of work, and only that kind of work? It's not even work. That kind of performance, only that kind of a performance, every day, every month, every year. They should get a raise for hurting people and hurting the state and hurting the nation and hurting the municipalities. They should get a raise for ruining our courts. Oh yeah. No way, Judith K. The plaintiff seeking to appeal from a judgment in favor of the defendants. Oh yes, he ruled in favor of the defendants, and he never had a law, and he never had any statutory authority. He never had any statutory authority to deny my ad damnum, which are carefully delineated. I asked him, I was within 3 feet of his physiognomy, and I asked him, what is your statutory authority? He was shocked. He had none. And then he looked at Callaghan, the Park Avenue lawyer, who's groveling for $3,000. He asked him for statutory authority, and Callaghan couldn't come up with it. And guess how the trial closed? That Glendora would submit a memorandum of law giving statutory authority for Lane to deny my ad damnum. Well, there is no such law. But we submitted 500 pages. George McDermott did it. He went to the Library of Congress. And he sent up 500 pages. Callaghan never did find a law. He was told also to produce a memorandum of law. He never produced a memorandum of law. He wrote a kid stuff letter. It wasn't a grown-up legal paper. And he couldn't find any statutory authority. And yet they go on, instead of doing the right thing, which was to grant the $3,000, Peter Lane denied it because he's colluding with Callaghan. You know what the word rye in the dictionary is? W-R-Y. Turned to one side, twisted, contorted. That's what the Rye City Court is. It's not the R-Y-E City Court, it's the W-R-Y City Court. And so Lane leaned on something from the Telecommunications Policy Act of 1984, codified as U.S. Code 47, Title 47, Section 521, et sequitur. He pulled something out of there that didn't apply at all. It had nothing to do with the case, and on that basis he ruled. And that's what I was trying to appeal. But I couldn't get it into the appellate term because I didn't have the minutes, because I didn't have $1,300. Can you see anything more crooked? What's a nation without courts? What's a nation without the ability to stand up for right? What's a nation where wrong is over right, and right is never over wrong? It's upside down. They have ruined our nation, and they want a raise, and they want a pay raise for that. State judges, New York state judges. Don't you give it to them. Well, anyway, Glendora says this is wrong, and that Glendora was not in forma pauperis because she paid for her fee. She paid for her fee for the appeal. It was that she couldn't pay the $1,300, and neither could you, appellate term, and neither would you, Rye City Court. The court below denied the application, and plaintiff moved, in essence, to renew pursuant to civil practice laws and rules 221E. I did not. That's poetic license. That's just not what happened. I was not renewing. I was simply asking them to pay for the $1,300, and since they wouldn't, then I appealed. The court below denied the motion on procedural grounds, and the plaintiff appealed. It was Peter Lane's court. It was his fault. The trial lasted 6 hours, and the minutes skyrocketed to $1,300, and even you couldn't pay for them. And let me just talk to you, court reporters. You are robbers. You are rip-offs. $1,300 for minutes. Are you? Okay, you're totally depraved. You're sold souls. You're greedy. You're avaricious. You're acquisitive. $1,300 for minutes. It's the biggest racket around. Get rid of courts reporters and let people take their own TV cameras and their own audio tape recorders into court and make their own record. They have every right to do so. But the dirty judges collude with the dirty court stenographers to steal the public's money and to make justice impossible. Because I couldn't appeal because I couldn't have the minutes, and I couldn't have the minutes because of the greedy court stenographers. Now, the appellate term had already asked that Lane had jurisdiction. I had already ruled that Lane had jurisdiction over Charles F. Dolan. It was prima facie. His name as the CEO of Cablevision Systems Corporation was all over the Westchester County Clerk's office. Yet Lane let liar for hire Robert M. Callaghy drone on for 6 hours about jurisdiction, and it was a dead defense. The trial could have been over in an hour, and the minutes would have been affordable, even for you, Peter Lane, and you, the appellate term. The very instant that Callaghy, liar for hire, now dead, a Park Avenue lawyer, groveling for $3,000, stipulated that he was not going to depend on the merits but on jurisdiction, that very minute the trial should have been over. There were no triable issues left. Glendora no longer had to present any evidence. Jurisdiction had vanished as a defense. It was Lane's fault that the cost of the minutes got out of reach, and you should have seen that. Appellate term. Rudolph, Tannenbaum, and McCarver. And in oral argument, 14 inches of snow, the 14th of February, Valentine's Day, you stated that Lane deprived Glendora of her right to appeal. You, Rudolph, said that. Glendora, in court, presented her ad damnum, all of which was carefully delineated to you in her 6-volume brief, to you, the appellate term. Lane denied it. Glendora said to him, "What is your statutory authority?" He was shocked into silence. He had none, and he looked to Callaghy for aid, and Callaghy had none. At the end of the 6-hour trial, Lane had no statutory authority for denying the ad damnum. So he dumped it on Glendora to produce a memorandum of law why he should have not denied the ad damnum. She and her friend George McDermott, who went to the Library of Congress, did and presented 500 pages to Lane. Lane told Callaghy to produce a memorandum of law also. Callaghy did not. His due date was March the 5th, 2004. That's exactly a year from this appellate term paper going against justice. 1 year. On March the 5th, it's 2 years. 3 years. On March the 5th, 2004, Lane told us to have the memorandum of law in. And on March the 5th, 2007, Rudolph, Tannenbaum, and LaCava double-crossed our nation, our state, our county, and our municipality. Well, Lane told Callaghy to have it in March the 5th. We got ours in March the 5th, but Callaghy didn't get anything in. At that point, Glendora made a motion for default, and she should have won it right away. What did Peter Lane do? He sent us a copy of Callaghy's letter of March the 5th. I don't even believe that he was such a letter, and that it was dated correctly, and that he did make the deadline. I just don't believe it. Anyway, I moved for default judgment, and of course, what did Lane do? He covered up for Callaghy. Nice boy. Good boy. And he protected the crooks. These are all reasons that Lane was wrong not to pay the $1,300 minutes. It was his fault, the whole thing, the 6 hours. And Glendora showed you all this in her brief, but you never read briefs or you never read minutes, and you made me pay $95 for the minutes. To this day, Lane has never been able to produce statutory authority for denying Glendora's ad damnum, and you should have taken care of that, and you should have done justice, you, Rudolph, Tannenbaum, and LaCava. But instead of doing your job, enforcing the law, you circumvent it, you, Rudolph, Tannenbaum, and LaCava, and you write hackneyed, worn out, trivial, frivolous slop like the following, and I will read this to you. You know, you put a quarter in the machine and out come these platitudes. Even assuming that the court erred in denying the motion on procedural grounds, in any event, substantial justice, and substantial justice, that we don't have substantial judges. It's substantial justice means only that it's money, that you get awarded money. The denial of poor person relief, and I didn't ask for poor person relief, I asked for them to pay for the minutes. I was not a poor person, I paid my fee. The denial of poor person relief was proper. I don't see why. Even assuming that the court erred in denying the motion on procedural grounds, no. I don't see that at all. The denial of the poor person relief was proper according to Civil Practice Laws and Rules 1101A, governing motions for permission to proceed as a poor person, requires in pertinent part, and then they go on to this quote that I'm going to read you. And Glendora says that this is kid stuff. It is pablum. It is all platitudes. It's dollars dishwater, as are your phony careers. They have phony careers. Their careers, if you can call them that, are built on lies, cheats, and steals. Glendora tells kids on the TV, do not grow up to be a lawyer or a judge unless you want to be a crook. You know that, folks? You cannot be a lawyer or a judge without being a crook. You have to be a crook. Do you want to be a crook? Then pick being a lawyer or a judge as a career. If you don't want to be a crook, eschew being a lawyer or